How did I become an IP lawyer with no interest in technology, no scientific background, and no idea that IP law or intellectual property law was even a thing? Great question. I would love to tell you, but be sure to stick around to the end because I'm also going to share with you guys the big secret of how people actually choose the type of law they want to practice. So if you're on the edge of your seat, smash that like button and let's dive in. So let's kick off this story with the type of law I thought I wanted to practice heading into law school, which was public interest law, even though I had no idea what that was or what that meant or if that was even what it was called. But that's for sure what I put in my personal statement in my law school application to get into law school. And I had some valid reasons for thinking that I might want to practice public interest law. And the main one was the one that most of us think of when we want to go to law school, which is I wanted to help people, even though I didn't know what that meant or how I was going to do that. And I was also a political science and Spanish major in undergrad, and I had interned at the state legislature every year of the 4 years of college, and I really loved it. And so I thought that something policy related would make sense, and I just assumed that public interest law might have some of those aspects in it. Now, when I got to law school, I quickly found out that most classes are all about reading cases, analyzing fact patterns, and writing legal memos. And that was all I was exposed to that first year. I didn't even know that there was an entire other area of the law that had nothing to do with reading cases, writing legal memos, and analyzing fact patterns, aka transactional law, aka corporate law. And my 1L summer, I wound up interning for the Human Rights Initiative, helping out with asylum applications, and the district attorney's office, helping out with a felony murder trial. And I was totally hooked on both. At the end of my 1L summer / the beginning of my 2L year, I participated in a process known as OCI, or on-campus interviewing, which is where bigger law firms, legal organizations, government agencies come to campus and interview you for a summer position for your 2L summer, the following summer. Now, I had just come off of a 1L summer internship helping prosecutors prosecute a federal murder trial that ended in a jury verdict of guilty. And I was completely enamored with the process and the work that they were doing. And I really thought that maybe being a prosecutor was something that I might want to do, either at the local level, at the district attorney's office, or the state level, at the state attorney general's office, or the federal level at the U.S. attorney's office. That being said, at that time, everything I had heard up to that point was that the best job you could get, the most prestigious job you could get out of law school was working in big law. And so there was no question in my mind at that moment in time that that was the job that I was going to try to get. Now, in OCI interviews, or really any legal interview for that matter, every interviewer is going to ask you, what type of law do you want to practice? Which is an insane question to ask anyone who's only been in law school for a year and has had literal weeks of exposure to maybe one or two types of law, but they're going to ask you anyway. And so I realized very early on that the best way to answer this question was to say that you were either leaning litigation or you were leaning transactional. Also, by the way, check out this video if you want a step-by-step breakdown of the exact wording that I love to use for this question. But since I knew at that point in time that I had liked asylum law and I had liked criminal law, and also I had a realization, I think at this point, and a recognition that the reading and writing aspects of the law were much more litigation based, I wound up saying in every one of those interviews that I was leaning litigation, which I think to this day was the right call to have made. That being said, litigation is an enormous umbrella under which there are hundreds of different types of practice groups that are litigation based. And I knew of two at that point in time, and I knew of no others, or that I would like any others, or that I would even like these two for an extended period of time. Fast forward a year to my 2L summer, where I was going to be splitting the summer between two law firms that I had chosen during the OCI process. One was a traditional big law firm, and one was an IP litigation boutique firm, which means a law firm that specializes in intellectual property litigation. So the first 7 weeks of the summer, I was going to be spending at the traditional big law firm, and big law firms are known as full service firms, which means they do all of the things, they have all of the practice areas. And so usually around April or May, before the summer begins, they will send you a questionnaire that asks you to rank the practice groups that you would like to work in that summer. I still to this day remember that questionnaire and having no idea what any of the practice groups meant or what they did. And the only name that really jumped out at me was the White Collar Criminal Defense Practice Group, because that sounded amazing. So I think I put that one as number 1, but I have no idea what I put as number 2 or number 3. And they ultimately put me in the Insurance Defense Litigation Practice Group. And then the second 7 weeks of the summer, where I was going to spend them at the IP litigation boutique firm, there were no practice groups because everybody at that firm did intellectual property litigation and specifically patent litigation. Now, as a summer associate, you're given different work assignments throughout the summer to show you the type of work that the practice group does, but more importantly, to be able to evaluate you on your work product and your pleasantness to work with factor. And then at the end of the summer, if you haven't done something truly heinous, like gotten drunk and insulted the managing partner's spouse, or gotten drunk and not turned in any of your work, you are generally going to receive a full-time offer to become a full-time associate in a year once you have finished law school and passed, or at least taken, the bar exam. And so at the end of the summer, I got a full-time offer from the traditional big law firm in their insurance defense practice group. And I got an offer from the IP litigation boutique, generally practicing patent law like the rest of the associates. So I had a decision I had to make. So how did I decide? The first thing I remember thinking about was the law firm itself. So on the big law, sort of traditional law firm side, I remember thinking that that was the safer bet because the law firm was big, it was well known in the community, it had a great reputation, it had a lot of practice areas. So presumably, if I needed to or wanted to change practice areas, I had that as an option. And then on the other side, the IP litigation boutique was much younger. It hadn't been around that long. It was not that well known in the community, and it didn't have any other practice areas that I could transition into if I wound up not liking patent litigation. The next thing I remember thinking about was how much we were going to be expected to work. And on the big law side, they had an annual billable hour requirement of 2,000 hours, which was very standard and still is. And then on the IP litigation boutique side, they had an expectation that their associates would bill 2,400 hours per year, which was insane. Even now, that number is so incredibly high and is almost unheard of in most law firms across the country. But I think what it ultimately came down to for me was that at that point in time in my life, what I wanted more than anything else was to graduate law school and become an amazing lawyer. I wanted to do all of the work. I wanted to learn all of the things. I wanted to touch every aspect of the case. And so the idea of grinding it out did not faze me at all if I was going to be given the chance and the opportunity to do as many things as I could get my hands on. And so at that point in time, I felt so much more inspired and motivated by this IP litigation boutique, which was this crazy ride that I was about to get on, more so than sort of the traditional well-defined roles of a big law firm practice group. And at that time, Sheryl Sandberg's book, Lean In, hadn't come out yet, but I remember that I read it years later, and there was a quote in there that really hit home for me that I think described this period of my life really well, which was, when you're offered a seat on a rocket ship, don't ask what seat, just get on. And so that was absolutely the experience that I felt I was going into by choosing this IP litigation boutique law firm. So that is the one that I ultimately decided on and accepted their offer to become a full-time associate. So the big secret of how people choose the type of law they're going to practice after law school is that they practice the type of law in the job that they're offered. And I know that sounds so basic and so mercenary, but the reality is that most of us will only work in one place our 2L summer, and whatever practice group that law firm has available is the one they're going to give you a full-time job offer in, which doesn't mean that you have to accept their full-time offer, and it doesn't mean that you can't change practice groups later. But we have such a limited set of data that we're operating on when we head into these interviews, our 2L year, our 3L year, or after graduating and taking the bar, that we don't know what type of law firm or what type of practice group we would enjoy or not until we're in it. And so that's how we figure it out, is in the days, in the weeks, in the months, in the years that we're doing this, is it something that we're enjoying? And not to mention that whether you enjoy a type of area of law so much of it depends on the partners you're working for, the associates you're working with, and the clients that you're serving. And so an area of the law can vary widely in terms of whether you like it or not from law firm to law firm. Now, that doesn't mean don't do anything, and it doesn't mean don't take any steps to understand different areas of the law. Those are all amazing steps that you can take. Just give yourself a break and give yourself some grace in not having an answer to this question, because I guarantee you that every single lawyer who is asking you what type of law you want to practice, whether it's heading into law school or even after graduating law school, had no idea what type of law they wanted to practice at either of those points in time themselves. And we find that out through actually doing it and through actually living it. So if you're looking for a good starting point to give yourself a first step into understanding the different types of law and what might be a good fit for you, definitely check out the What Type of Lawyer Should I Be quiz, and that will begin to give you some of this insight. Another great step to take is informational interviews with lawyers working right now in the areas of law you think you might want to practice. And if you're curious about what that looks like, definitely check out this video here too. So I hope that was helpful, guys. Feel free to drop any questions about my own journey in finding the practice area of law that I wound up going into in the comments below. And I will see you guys in the next video.